Good night. Good night.
Nice.
Hello. Y'all can hear me.
Yes.
Oh, okay.
Um,
Good evening, everyone.
Good evening.
How are you?
Alive and kicking.
Okay. You saw the questions I sent?
No, when is the same questions?
Oh, just now.
Oh, okay, let me check my email.
Yeah, I looking at them like,
Huh? Who was that just now, Christina?
that's mom.
What you saying? You looking at the questions and what?
No, I just said I'm looking at them.
Oh, okay. No, we're gonna do the chapter first and then we'll look at the questions. We're gonna do chapter 7 and then you look at the questions before you start panicking.
Okay.
Okay?
Panic mode didn't start though. You should have stayed
Oh.
up first.
Yeah, but no, hold on. Don't start yet. Let's do chapter 7 first. Chapter 7 is always important. So let's do chapter 7. Everybody had an opportunity to read it?
Chapter 7.
Yes, unit 7, company management.
No,
Oh, Lord.
it's focusing on sex.
Yo, okay. All right. Well, we on 7 today and then we'll do 6 afterwards. So let's start on 7. 7 is not a hard read. It's
For
not like
someone
6.
that knows it.
Oh, Lord. Okay. So we know from company law 1 that a company has different organs. One is the board of directors, one is the shareholders, the other is the board of directors, and underneath them is management, or what you would call the officers of the bank.
Mhm.
So one of the most important thing is when a company is formed, normally they draft a shareholders agreement, and the shareholders agreement determine how they would like the company to be run. So the shareholders, when they have the annual shareholders meeting, they will appoint the members of the board.
You said the
And-
shareholders agreement basically says how they would like the company to be run.
Yeah,
Okay.
they will give particulars on how they want the company to be run. What they're looking for. And then the job of the directors then is to carry out that mandate in accordance with the articles of association. So the directors in their meeting, the shareholders in the meeting, they will appoint directors. They manage the company. So their job is to make sure that whatever the shareholders had agreed to in terms of their strategy, their risk appetite, how they would like to see the company formed, all of that comes from the directors.
Mhm.
So the shareholders are normally not involved in the day-to-day management of the company. The shareholder can, of course, be a member of the board. He can be appointed as a director. A shareholder may also be appointed to a position within the company itself, such as being a manager of a different department. So the Companies Act doesn't really define the word director or the word officer. But we do know in common law, they have fiduciary duty. And that is, they have the job to manage the company, but they have to act honestly, in good faith, and in the best interest of the company. And they do that subject to the shareholders agreement, and of course, the memo and arts of the company. So just like any ordinary man, when it comes to law, as the ordinary man, the director has to exercise his duty of care, and he has to do it with skill as a reasonably prudent man would exercise in such a position. So you notice always when it comes to exercising any right, any duty, the law always says it has to be reasonable as a prudent man would do. So it doesn't matter whether you're an executive director or a non-executive director. You still have to act as a prudent man would do, using the skills that you have. So as a director in common law, you have a fiduciary duty. And that duty is a legal duty because it arises by law. So it means that they always have to act in good faith. They cannot profit from that position. They cannot place themselves in position where their duties as directors conflict with their own personal interests.
So no conflict of interest.
No conflict of interest. They can never act for their own benefit or for the benefit of others, like friends of theirs. Unless, of course, the memo and articles authorizes them to do so, or they have the consent of the directors. And obviously, directors can only give you that consent if the articles allow them to. Otherwise, they're gonna have to ask the shareholders. But they have to always remember, if the company has shares, that they have to deal with the shareholders fairly in each class. So we all know that once you subscribe, once you send in your documents for the memo and articles, the subscribers normally would appoint the first set of directors. So like I said, when I started, directors are appointed at the annual shareholders meeting. Normally what they do is they ask for all of the directors and officers to be removed, and then they are reappointed each year. So the appointments are governed by the Articles of Association. And when you appoint directors, again, you have to look at what does the shareholders agreement state, if there is a provision in it. The articles will also state when a director can be removed, or what happens if there is a vacancy, or if you wanted to add another director. The articles speak to that. If it doesn't speak to that, where do you go?
You said the articles doesn't speak to it?
Yeah, where do you go?
To the act?
Shareholders agreement.
To the who?
I say to the act.
Where does it say it in the act?
In the first.
In the first schedule. Yes, that's where you go. The first schedule.
102? I think, maybe.
The first, yeah, go to the first schedule. It will tell you how to deal with removal, appointment of directors.
Okay.
And even as the articles will also state how many directors you should have. So once you're appointed as a director, they need to sign a document which says that they agree to be a director.
You say
Then
that the articles would say how much, but by law, for the companies, there's a certain amount you have to have, correct?
No, why you have to have a certain number of directors? What do you mean? It means when at incorporation?
Yeah.
No, this now is speaking about when you're running the company. You get the number of directors that are required in order to run the company.
Okay.
Right. And you remove them based upon your strategy. If you were first selling fans and now you're selling cups, then you need someone with a different perspective. If you go in a different market, you need someone with a different perspective.
Or a different skill set then maybe.
Yes. If you're now moving from doing it manually to doing it by technology, you need a different set of directors. So when you appoint a new director, Like I say, they have to sign that they agree to be a director. Then as a director, they need to ask the company what kind of insurances and indemnification do they have, which means the protection. They should always ask that. You don't wait until you're in trouble. That's the first question you ask. What type of insurance do you have to cover professional indemnification? Does your banker's blanket bond insurance, which covers the all risk insurance, what provisions does it have? If there is a suit that's against me for negligence, then you need to give a new director a copy of all of the corporate documents. So normally what is done is you would prepare what you call a director's handbook, or if you have the electronic platform, because you know now directors don't actually have to have paper. You can, there's what they call a board data. Different companies have it. And in that you prepare portfolios, one for board meetings, one for managers' various meetings, one for charters, one for policies, and it's all in there electronically. So once you appoint a director, you have to ensure that he receives the copy of the insurances, professional indemnity. Then you have to also include the memo and arts. You have to provide the latest financial statements, the last minutes of the board, in case they have any questions. You would also include in that packet a listing of all policies and procedures. You would add in there also a brief history of the organization. You would also state in there the remuneration on a quarterly basis for being a director. It depends on whether the entity is regulated or not, or a company may just do it as a part of best practices. What they would actually do is have the director sign off that they will abide by whatever code of conduct or ethical standards that they have established. And that's done annually. Then you would also provide the board with a table of all of the statutory filings for the previous year. And so they're well versed as to, as each quarter comes, each board meeting, they are aware as to what needs to be tabled before them for approval. So the next thing is that there are two types of directors. You have executive and you have non-executive. In law, there is no distinction between the two. An executive director, he works full-time in the company. So he's the person who's responsible for the day-to-day operations, carrying out the strategic plan of the shareholder, doing the planning and the business development. That's the executive director's job. The non-executive director, he just attends the meeting and he gives advice to the board of directors. Normally, the executive director is not paid any additional sum because he's already employed as an employee. So in addition to the executive and non-executive directors, you also have nominee directors. So if you look at it from when we refer to IBCs and how they are used for structuring wealth management and asset management, you can have an IBC that acts as a director in a nominee capacity. And normally for that arrangement, you would have a corporate management agreement, which states what it is that they're supposed to do and on which company are they doing it for. There's also under company law, something called shadow directors. And these are persons who carry out acts within the company then the company relies on the comments or the recommendations that they make during the board meetings. So that means that when a decision is made by the board, they rely on that information from that person who is not a director. And in that instance, once they rely upon it and they act upon it, in law, they are considered to be a shadow director automatically.
Repeat that, what you just said?
Even though they are not a director, but
Mm-hmm.
when they make a let's say they come in to make a presentation.
Mm-hmm.
So they come in to make a presentation. Let's say they are a former director who was with the company for a very long time. And the person still comes to the board, but not as a director. He just comes to give advice. So let's say in one of the meetings, he gives advice. Then he gives some recommendations.
Mm-hmm.
If the board, the other directors agree with the recommendations, sanction that recommendation, ask management to carry out that recommendation. And let's just say they find out later that it shouldn't have been done that way. Because the board relied on that person's information, ratified it at the board meeting, and it was executed, that person is considered a shadow director.
Okay, because they carried out whatever suggestion was made.
Yes.
Okay.
So it has to be something that they said, and then there was a decision made, and the board carried out that decision. So a shadow director was always recognized in common law. The Bahamas just recently did it in 2011. And they define it as any person in association with those directions or instructions. The directors of the company are accustomed to act, but the person is not deemed to be a shadow director by reason only that the directors act on advice given by him in a professional capacity. So if he then says, I hereby give you this advice as a qualified engineer, that is totally different from him giving deliberations and giving recommendation and decision-making indicators for the board to make a decision. And once you are labeled as a shadow director, then you have a liability as any other director who is duly appointed. Normally, the test as to whether or not a person is a shadow director is based on whether or not they had real influence in the corporate affairs of the company. That's the test. So yes, he may have made a statement. Yes, he made a recommendation. Yes, the board relied upon it. Yes, management carried it out. Yes, there was some negligence or the company lost money. The test then comes, did he have real influence in the corporate affairs of the company?
What determines that?
It's based on case law.
Okay.
What you have to do is you have to look to see whether or not he wielded influence over the participants. Because what the court will look at is whether or not, based on the decision, it would have affected shareholders. It affected management. It affected the affairs of the company. He has to show that based upon what he said, he is the one who caused the directors to come to that decision. That's why it's called real influence. So as a director in law, like I said, once you are appointed as a director, you have a fiduciary duty. It's not your responsibility to come to the board meeting, sit down, say a few words or say nothing and then collect your check every quarter. Being a director, inherent in that position are fiduciary duties. The director has these duties imposed legal and statutory. So they have a duty to act in good faith, to promote the success of the company. They have to act in accordance with the company's constitution. That's the memo on arts. They also have to act in the best interests of the company. They have a duty to exercise reasonable skill, care, and diligence. They have to exercise independent judgment. And you normally get that from what we call the INED, the Independent Non-Executive Director. Their role is to give independent judgment. Then you have the duty to avoid conflict of interest, the duty to manage the company, and a duty to treat all classes of shareholders fairly. So you will not see in a contract when you decide to be, or an agreement when you decide to be a director, these duties. They arise by operation of law. Just taking on that position, once you say, I am a director, these duties arise. So when you sit around the table and you're deliberating and making decisions and agreeing, you have to ask yourself, is this decision the best decision for the company? Will this decision conflict with a company that I am involved with? Did I declare that I own 10% of this company? Did I declare that I own 5%? Did I declare that I own 75%? Did I declare that the owner of that company is my aunt, my cousin? You have to make all these declarations because you have a duty not to have a conflict of interest. And I know conflict of interest is a very difficult term for Bahamians to understand. Because whenever you speak of conflict of interest, they say, oh no, that's not a conflict. A conflict of interest is anything that more or less fogs your duty in the capacity that you have been appointed. So if you have a duty to manage this company and you have to exercise the skill and the due diligence that you have, and you cannot be in conflict with the company. You cannot go and contract business for the company from your company unless you declare it to the board and they agree. Or what's the other suggestion?
So hold on, I just want to get sort of the conflict of interest is when the personal interest then collides with the professional interest or to the company.
It don't have to be personal. Like I was saying, let's say you have a company you want to buy paper from, and that company is owned by your cousin, a relative. You should declare it.
Okay.
You should declare it because it becomes a conflict. Because normally if you're dealing with something like that, you declare it. If it's not coming directly with you, in front of you, you still need to declare it.
Because it could come up.
It can come up.
Okay.
Exactly. So if you, well, that won't be a good example. I was going to say the one that was in the paper Monday, but that's not a good example. The one with the Ministry of Finance and the worker. You did read the paper, right? Monday's paper? Newspaper? Who read it?
Which one?
The Ministry of Finance. No, yesterday. The Ministry of Finance. Yeah, the Ministry of Finance employee.
Oh, with all that. Well, that's a small fry compared though, but anyway.
No, but look at the structure. How was the structure done? The company was hired to do a presentation, and the company was owned by that person's aunt. And that same person, along with others, wrote up the vouchers with the overprice. There's already a conflict from the very beginning. And it should have been declared. He should
But
not have been
it
allowed.
ain't get declared if the motive was to move money.
Yes. The person went to jail.
That's what I'm saying. It was his intention to move the money how he moved it, so that wasn't getting declared.
It depends. It depends because the argument is that he didn't get much of the money. So he must not have been the brain. He would have been the access to get it done, to facilitate it. You see what I mean? You're the person who's going to write the vouchers or clear the vouchers, whatever one it is they do. And there was a clear conflict, should not have done it. Regret it now, but it's too late. So the question you always ask yourself is, to whom are the general duties owed, or who are their beneficiaries? So as a director, you know that your duty is owed to the company. Always remember that. The duties are owed to the company. And only those who are able to act as or on behalf of the company can enforce the duties. So in the case of Pexkin versus Anderson, they distinguish between the fiduciary duties owed by directors is to the company, which arises out of the relationship between director and company. And fiduciary duties are owed to shareholders, which are independent upon establishing a special factual relationship. So you see there's a difference. They have a fiduciary duty that arises out of the relationship between director and company. And then they have a fiduciary duty that is owed to the shareholders. So by whom are the general duties owed? So once a director is appointed, that's to whom the general duties are owed. Now, there are also shadow directors, and they themselves can be also under this general duty if they act as such. So in the case of Reed Smith and Forsyth, it said that directors must act in the best interest of the company and cannot use their powers to benefit themselves or third parties. So third party means anybody that you're related to or anybody that you are doing business with. The legal test is always whether a director has in fact acted in good faith. And that is, he believes whatever he did was in the best interest of the company. But directors have to always exercise their powers for the purpose for which those powers were given. So they can't just say, well, they acted in good faith and that it was in the best interest of the company. They have to make sure that when they exercise their powers, they exercise it prudently. And that means that it has to be fair and objective. And that's what the courts look at. And they assess the propriety of the decision and the action of the directors. Because whenever you think about what's in the best interest of the company, that is always subjective. Because that director, when he makes a decision, he is saying, I think this is in the best interest of the company. But he has to do it within whatever he makes or states is a best interest of the company. He has to make sure that there's no familial interest, there is no third party interest, and that whatever he's doing is ethical. That's the next thing that we need for all Bahamians to have. A course in ethics.
So, Ms. Archer, I have a question.
Go ahead.
If a shareholder has another company, really different from the main company, and the director, let's say the director needed some supplies, and the shareholder has this other company that has these kind of supplies, like office supplies.
Mm-hmm.
And if the shareholder were to tell the director to purchase from his company,
Mm-hmm.
because he has a better product, he necessarily doesn't have a better price, and that's his opinion.
Mm-hmm. Mm-hmm.
What is the shareholder? What is the director's dilemma if he doesn't want to go with it? If he wants to
But don't
purchase
forget
it from a
now.
cheaper option.
Okay, now don't forget now. If it's a one-man band, like an IBC, there's only one director.
Mm-hmm.
If he's in a company where there's more than one director, that position has to be placed on the table for all of them to take a vote. If there is more than one shareholder and they take a vote, and that other shareholder then says, after I say they bought it, like you're saying, and let's just say it didn't work out well. They found out that it didn't suit the company. It didn't do what it's supposed to do. The other shareholders can then say, hold on now. He brought this to you all. You all decided upon it, but it was not in the best interest of the company. And those shareholders can bring an action against the directors for negligence.
But they wouldn't bring it towards the other shareholder who had the interest in the other business.
No, because the directors is the one who have that responsibility. Their duties to the company.
I just want to make sure. I mean, because I know the shareholders, the director have to answer to them too, right? Have a responsibility to them too after the company.
But don't forget now, what the directors do is directors just provide the financials. Ensure that they're getting dividends. With the comfort that they're running the company in accordance with the memo and arts. They don't get involved in the day-to-day unless, like I said, the shareholder then decide that they want to be a chairman. So then they would be actively involved. But really the only thing they see is they appoint the auditors, they appoint the board of directors, the remuneration of directors. If you need capital increase, if it's a private company, or if it's a public company, the private company, they would say, we need a capital increase. But other than that, no, they don't get involved in the day-to-day management. They're not supposed to. So let's see.
Our shareholders you was talking about just now don't get involved in the day-to-day, right?
Yes.
Okay.
Mm-hmm. So it is a duty of directors to exercise their powers for a proper purpose. Like I said earlier, that courts fairly and objectively monitor and assess propriety of the decisions. And like I said, it's a subjective test. Directors always have to be seen to be exercising their discretionary powers independently and fairly in all matters. So that means if 6 of us are on the board, right? You get the agenda beforehand, you get the documents beforehand. It's not expected that me and Raven call each other on the phone and we say, you agree? I agree. Okay, I can say I agree. And so when we go around the board, who all in favor of this motion? Raven put a hand up. I agree. I speak on behalf of myself and Christine. No, that doesn't happen. It's not supposed to happen. Everybody has to speak and they speak independently. They speak for themselves in order for the vote to be taken. And if you are tabling something that involves one of the directors, they have to leave the room and they have to abstain from voting. So in the case of Movitex and Bullfield, that case established that directors do not have a duty not to place themselves in a position of conflict in and of itself. They should not place themselves in a position where their personal interests or duties to third parties conflict with their duties to the company, unless they have the consent of the company.
Sorry, what's the name of the case? You said
Mo-
Movitex?
Movitex, Movitex versus Bullfield.
BULL?
Mm-hmm.
Okay.
Directors, in some instances, may be given the consent in the Articles of Association, or the board can do it by resolution. Directors are also prohibited from gaining a profit or obtaining some benefit by using some proprietary information or trade secrets or opportunities that may belong to or derive from a company for which they act as directors. So we're back to the same point when you were saying, if you own a company and then you want to decide to, guess what? I bring in toilet tissue. My paper is good. My price is more competitive to what's in super value. So I think the company should buy it from me. They should not place themselves in conflict. So you'll have to declare that to the board, providing the information, the comparison. You excuse yourself while the deliberations and the decision is being made, so that there is no conflict. And I find that's what Bahamian people normally don't appreciate. So normally what they do is they say, oh, how they get the contract again? They're already rich. Plus they're on the board. They shouldn't have that contract. But if the person has excused themselves, they've put in a bid like everybody else, or sent out a quotation like everybody else, and now it comes to the board to make that decision. And the board make the decision based on what's in the best interest of the company, without them being present. So the directors, they have to manage the business and affairs of the company, subject to any limitation or restrictions that's in the constituted documents. And also being mindful of the unanimous shareholders agreement. In the case of mutual life versus ranked organization, they said it is imperative that the shareholders of the company, as one of the primary stakeholders within the corporate governance regime, be treated fairly in the proper distribution of dividends, the allotment of shares, access to the company information, and in corporate decisions made in accordance with the memo and arts. So directors are generally responsible for the management, and they exercise the powers over the company. But they don't have unlimited powers to run a company. They can only exercise the powers that are granted to them by general law, or by the articles, or by the shareholders agreement. The director's authority is restricted by the Companies Act or the IBC Act and the Articles of Association. So that's sometimes like when you see a company wants to borrow money, the bank will actually ask for the authorization. And so the authorization will be a resolution that comes from the corporate secretary stating that these persons have the authority to bind the company for a certain amount for a certain period. And it is expected that the corporate secretary would have reviewed the Articles of Association to see whether there is any limitation, or the shareholders agreement, whether there's any limitation as to how much they can borrow and how long they can borrow, and where it states what purpose they can borrow for. And so the bank would rely upon that resolution to actually state what they can and cannot do, because it will say in accordance with whatever. So the Articles of Association entitle the board to delegate powers to individual directors as considered appropriate. But they must collectively, as a board, they have to bind the company. So we know that being a director, you have all of those duties. You also have liability. So any breach of those duties will amount to a breach of director's duty to the company. So as a rule, a director cannot be liable for the fraudulent, criminal, or bad faith acts of his co-directors if he hasn't taken part in the act, or if he doesn't know about it, or he doesn't have any suspicion. But if a director is involved, he is jointly and severably liable with the other directors. And because he may be jointly and severably liable with the other co-directors, then by law, he has to make good the whole loss with a contribution from his co-directors. And the only way it doesn't happen that way is if he misappropriated for his own benefit. Directors, if they receive a secret profit, they are liable. And by being a fiduciary, it means that they are liable to account. So that means that they have to account to the company for any secret profits they have made. The company, in turn, they're entitled to void any contract that may have been made by this director. And any property that the director would have sold has to come back to the bank. The bank has to recover it. But the bank cannot recover property that was sold to what we call a bona fide purchaser for value, which means that that person had no idea that, one, the director didn't have the authority to do so, and two, that the property was owned by a company. So that means that that person that he sold it to, because they were not aware of those two factors, then they would have taken that property in good faith and for value. And they do not, that the bank cannot recover, or the company cannot recover. Note that in the case of Bramford and Bramford, a company may by ordinary resolution waive a breach of duty by a director. And the court has a power to grant relief to a director who has acted honestly and reasonably, and who, in review of the facts of the case, ought to, in the circumstances, be exonerated. Now, as a director, you have to make sure that you have indemnification. Because as a director, you want protection from liability and any risk from the company. So under the Act, it allows the director and his legal representative to be indemnified by the company against all costs, charges, and expenses which may be reasonably incurred by him in respect of any civil, criminal, or administrative action or proceedings, either by him being or having been a director of the company. IBC Act has a similar provision. So the statutory right to indemnification is only permissible to directors and their legal representatives of both the Companies Act and the IBC Act, provided that such directors acted honestly and in good faith, in the best interest of the company, and where they had reasonable grounds for believing that their conduct was lawful in the case of criminal or administrative action or proceedings. So notice the key words when you are a director. You have to act honestly, in good faith, and in the best interest of the company in carrying out your duties. And those duties are statutory duties, and they're also common law duties because they arise by you being a fiduciary. So since a director or an officer of the company may be personally liable to any party that may have an interest in the affairs of the company for damages, legal costs, and expenses, they normally seek the protection of directors and officers' liability insurance.
Sorry,
And-
you just say they have to act honestly, in good faith, and you said one other thing.
In the best interest of the company. So the directors and officers insurance, that's normally, you would normally get such coverage to protect the director or the officer against any claims that may be made by a company, a shareholder, or a creditor. So the Companies Act allow you to purchase such insurance for the benefit of a director against liability. Now that liability, when it occurs, it has to be in his capacity as a director. So that means that when he acts as a director, he has to make sure that he is acting within the powers that were given to him in the articles and also in the unanimous shareholder agreement. So even though when he was appointed as a director, he would have been given a copy of the both insurances of a company, a banker's blanket bond insurance, which is an all risk insurance. And then he would also be given a copy of the insurance.
You went out, Miss.
He has to make sure
I didn't get the last part. Can you repeat that?
that
again?
coverage
Bankers?
includes banker's blanket bond insurance, or what you call an all risk insurance. It covers all the risk in the company.
You said
That is
bankers
different.
what?
Banker's blanket bond. Or you can call it an all risk insurance. So usually it has it covers all of your general risk that are associated with your business. But you also will purchase a professional indemnity, which is just for the directors and the officers in the event that they are sued for negligence.
You say a professional
act
indemnity
allows-
just for them?
Yeah, for directors and officers.
And so how do you get the value for that?
What do you mean?
Like, so when you go to get that, you'd say $1 million, 2 million, but what would be based on the value, the type of company it is?
No. What the amount that you get would be based on what you think any possible claim can amount to. So you wouldn't go and get a professional indemnity for $500,000. Because your coverage has to be for the damages to the company, whatever that could be, legal costs, any other expenses that's related to it. So you wouldn't want to cover your directors and officers for a mere $500,000.
And the payout would come out to the decent damages would be the payout, the legal costs, and
any other expenses related to whatever that action is. Don't forget now, the claim could come from the company itself. It could come from the shareholders and it also can come from creditors. Under the IBC Act, it states that coverage is for the director, the registered agent, the officer, and the liquidator, as long as they're acting within their capacity. So once you are appointed as a director or as an officer of a company, you have to ensure that you have adequate coverage. And that's why I said, once you are appointed, whether you're appointed as a director or you're appointed as an officer, you need to read the insurance coverage before you accept those positions. Because you could end up paying out of your pocket if there is insufficient coverage. So policy, it tells you what's covered and what's not covered. And you need to be cognizant of those things. And then how many people have read at least a summary of what happened in Enron?
You mean with, you know that one, hold on.
Enron, WorldCom, all of those that had
And they
bad
couldn't-
corporate governance.
Yeah, they had to shut down, right?
Oh yeah, they were shut down.
And the monies were lost to investors.
Lots of money were lost. They were doing their own thing.
Yeah. With the
And
with like financials and stuff, right?
Yes.
Sort of
What
like,
would go ahead. What would WorldCom? Let me look up Enron first. Enron tells you what not to do. Okay, let's see. See if I can find something that's simple. Not too difficult to read. Okay, so Enron. First point was, hold on, let me show you. You want me to send a link?
yeah.
Okay, let me send the link. Copy here. And I just sent you all something.
So there's basically in more debt than they were letting the shareholders know then.
Mm-hmm. Hold on, I'm trying to find it. I just sent this to you all.
I don't remember. I know I
Back it
heard
up.
the story like twice.
Okay, hold on. You should have heard it more than twice. I just sent it.
Emailing.
Yeah. Mm-hmm. So it says, the case study discusses how Enron evolved as a company. It tackles the strategies and processes employed by Enron on its business innovations, personnel management, and risk management. This study also delves into the downfall of the company, including the problems and breakdowns it encountered and had to deal with. Finally, this case study gives a review on the fall of Enron as a company and leads the students into understanding governance and management problems which affect the company as a whole. Now, hold on now. I click a button that tell me I must pay $8.95. I'm not doing that. So see where it says, Poor management was greatly at fault. Kenneth Lay, the CEO, and Jeffrey Skilling, the president of Enron, promised investors ambitious profits, to say the least. The company's supernormal growth was centered on the deregulation of the sector, yet most states had not done so. Enron spent a lot of money lobbying for deregulation as it would greatly open their market. Enron's executive board quite craftily attracted investors to put their money on unstable business models. Most of these deals flopped, and they concealed the true performance of the company. They hyped their stock price to very unsustainable levels, with a large number of their shareholders suffering a great loss when their bubble bursts. Mr. Skilling, that's the president, resigned in 2001, and Mr. Lay resigned the following year, while Enron was on a sharp decline.
So
Then,
they
of
do-
course, go ahead.
I say they messed them up and then push out before the crash.
Of course. So accountants and auditors were also at fault. Investors were not made aware that Enron was failing. Losses were creatively accounted for as new joint ventures and partnerships. This false accounting kept stock prices high, and some of the executives even sold some of their shares in the company. Suddenly, the company announced losses, and it came to light that it had erroneously reported its earnings for several years. The accountants, the firm of Arthur Anderson, even went as far as destroying documents that showed damning irregularities in Enron's bookkeeping and financial reporting. So if you know this story, when they would have gone to get the documents from Arthur Anderson, they met them at the shredding machine, shredding the documents. They failed to fulfill their duty to the public and investors who expected them to objectively assess the company's stability in order to inform their investment in the business. They were in breach of the ethical laws and professional accounting standards. They were sanctioned by Congress during their investigations into that case. That's why that accounting firm started to go down. Now, point 3, government of the day. Several politicians were corrupt, and on several occasions are believed to have received bribes from Enron in the advancement of their causes. Because don't forget now, they were trying, because of deregulation, they were paying off people in order for them to get what they wanted. So no one was keeping the accountants and auditors accountable, and their word was generally held to be true. The SEC authorization of mark-to-market practices by Enron also enabled the company to defraud many of the investors legally. Now we come to corporate governance. The board, management, and other stakeholders all have defined roles, obligations, rights, and responsibilities outlined in corporate governance principles. So what's the role of the board?
So act in the best interest of the company.
Right, to manage the affairs of the company.
Mhm.
So what's the role of management?
The role of management
To run
is
the
to
company?
take whatever procedures, I guess, came out of place from the directors and work them out throughout the company.
No, not procedures now. Management will prepare procedures for staff to carry out. They also draft the policies, but the role of management is to run the company according to the strategies that have been handed down from the board,
To
based
take the
upon the
directives from the
shareholders.
board.
Right. So, like they say, corporate governance, that's the board, the management, and all the other stakeholders. So the stakeholders are also the employees and all your vendors. Everybody have a defined role, they have their obligations, and they have their responsibilities. So despite Enron being lauded as one of the top 5 companies with the best corporate governance setup, several governance principles were flagrantly breached. 1, independent auditors have authority over the audit of all the company's affiliates and divisions. The firm acts lawfully and ethically in dealing with shareholders. Proper procedures and control over management day-to-day operation. The external auditor is free from management influence. The firm's financial, operating, and governance activities are reported to shareholders in a fair, accurate, and timely manner. Proper accounting and auditing procedures have been followed. Detailed disclosure of the risk associated with the business. the financial and operating results of the company, fees paid, and the nature of new audit services performed by the auditors. So the principles were deliberately ignored for the growth of Enron and making the business profit-oriented. And Andrew Fastow and Jeffrey Skilling changed their business strategy, and they appeared to make Enron very profitable and innovative. And they stopped it right there. But there's a whole book on this. Very good reading. It's very thick, but 300 and something pages. Someone stole my book.
Oh, you got an
But
actual book?
I read the whole book. It's just unbelievable.
300 and something pages?
It's very thick, yes. But it's a very good book on corporate governance and what not to do. You should read it. There are quite a few cases. I think this will make a good exam question.
No.
What's the question?
No.
What you mean no?
What's
No.
the exam question?
Katina, why you saying no?
Because it sounds like you see all those things you said that they did wrong. You could imagine where the question would come from. All I'm listening, you would list 9 things that they did wrong.
Those are all principles and they did the opposite of each one.
I know. Like, but that, like you mentioned one. I can't see that being a question, that.
Why?
This is stage 1. Company law stage 1.
And do you know what company law stage 2 is about?
I even scared to look.
No, it's not like that. You're not gonna be learning the next half of company law itself. You're gonna be looking at other vehicles because we are an asset wealth management jurisdiction. You're going to be looking at other structures that are similar to companies that we offer to our clients, looking at the distinction and the differences. And then you
different
move
investments, that's what you meant?
different vehicles. So you're looking at foundations, you're looking at trusts, you're looking at icons, looking at Bahamas executive entities, you're looking at private trusts, and then you add on top of that risk management, and you also look at data protection.
You do SACs too?
Yes, we do SACs too. Yes. So don't get scared. I mean, we could do a pure company law too, but it'll be more case intensive. So you wouldn't want that.
No.
No, right? But this is
No.
but this is a very good question.
What is the question though? You didn't say what the question is.
What's wrong with you? Stay calm. I've not even heard from Christina tonight. I want to talk with Raven and Shaquille and see what happening. Y'all asleep or cooking?
No, ma'am, I'm reading through because I didn't have an opportunity to read ahead. So I'm reading through as you're talking. And yes.
Wait, don't laugh. Hold this thing. Why the fuck would you laugh though? Wait, you just like, that's what I trying to talk. Are you trying to get on it to fucking talk?
Excuse me?
Christina.
Oh my God, you can hear me?
Yes.
I battling with my friends. They're telling me like they can't hear me. I talking and they can't hear me. And now you can hear me. I'm so sorry. Oh my God. I take all that back. Sorry, guys.
You take it back. Okay.
I didn't know you were going to hear me. I was talking. Oh my God. Don't laugh. Please don't laugh.
Okay, we stop. Anyhow, so let me see what I can find. Oh, I found something very good. Let me send this one instead. I remember these two. Hold on, let me go to.
Ms. Archer?
Yes,
I'm
my dear.
looking at the compiled case studies that we got as a part of the downloads for this class, well, for the whole session. Here's my question to you. You brought up Enron and another case. that were not part of this case study. I mean, for me, I was reading through so I guess I could get the gist of the type of cases that you'd bring up.
Okay.
Why wouldn't Enron have been a part of this packet?
Hmm.
This lovely 48-page packet. I mean, there's something similar, granted, but
Lovely 48 page.
yeah, it's quite a bit. I mean, okay, here's the thing, because I'm in trust, I'm in corporate trust and corporate, I don't get so much case studies as would someone, I guess, in law. And so for me,
Enron case study in there.
pardon?
You say Enron, right?
Uh-huh.
Yeah, case study in there for Enron.
Oh, really? Which case study is that?
It's a Enron case study. It's like a.
See, at the top, they have case study 1, case study 2. Which one is Enron's?
No, I have a
very
file.
similar.
I have a file that is strictly, it just says Enron case study.
Okay, I'll have to go back and have a look.
Which one you looking at? What's yours name?
Is it says case studies on fighting money laundering, terrorist finance, and economic crime.
Oh no, I don't even have that.
This was sent out by Mr. Pratt. It was sent out by Mr. Pratt. And I'm thinking that it was a part of the packet that had the CAC act.
That same one. I see what you mean now. That 48 page, yeah, that same one. I think in that same email, the Enron one was in.
Really? Okay, I'll go back and have a look.
Okay, look at the link I just sent you.
Okay.
The case of Enron and Parmalat.
Parmalat, yes.
Parmalat, what, milk?
Yes, it's another famous case.
Really, we love Parmalat. Don't tell me they have a situation.
They going down though?
Well, they had a lot of issues. So this one is only 8 pages long.
I see, look here, look at God.
And the writing is big.
That is not big.
It's huge to me, and I'm blind.
I must have gotten something different, Miss Archer, because I have at 7/19 is when you sent this, and this is again Enron. I got Enron twice.
Hold on, how you get Enron twice?
I have no idea.
I think it is Enron and Parmalat. You have to open it up.
Yes,
Okay.
yeah, the second one is Enron and Parmalat. Yes.
Okay, let me just open it there.
Open that one up.
No, the second one is still the fall of Enron. Maybe I'm.
No, Parmalat is at the bottom.
Oh.
Parmalat is there.
Okay, I just have to read through. Okay.
Yeah.
No, it's a different link.
What do you mean? Which one
My
are you?
one is-
Okay. Which one are you looking at?
The one at 7/19, that's
In
the one she can't find it.
The one at 7/19, the one at 7/19 to me has is Enron. They're both the same. It's the same as the one that I received at 7/08.
No,
Can't
if
be.
you look
Oh,
at
no.
the one at,
No.
look at the one
Oh,
at
I see.
7/19,
Sorry,
that's the
I
link
have
at
it.
the
The
top.
7/19 has the link.
I have it. I
Have it.
clicked on the link. I now have it. Thank you.
Okay. All right. So look at the link I just sent you just now. It gives you the top 10 accounting scandals in the past decade.
You sent a next one something just now?
Yes.
Oh,
So this one is on a company called Waste Management Scandal, publicly traded company. The company's new CEO and his management team discovered that the company had reported over $1.7 billion in fake earnings.
I get that one yet.
what time you
I
sent that?
haven't gotten it yet either.
What you all don't never get nothing now.
No, I ain't get that one either.
No, it hasn't downloaded yet.
Yeah, that money ain't come through yet, Pat.
Oh, I see why. My internet dropped.
Okay.
Let me see if I can put it back on. Let me see. Let me put it in. Good thing you said that, because I would have been talking and you wouldn't figure out what in the world I'm talking about.
And that is
Very
trusted.
clueless.
Okay, let me connect. I hate when it does this. They say that's when it's too many people on the network. Okay, you should have it. It just connected. Oh, let me hit send. Let me do it. Okay, it's a sent. Have it now?
Yeah.
Oh,
Okay.
yes.
Okay.
Accounting
So,
scandals, you said, right?
Okay, yes,
Yeah.
got it.
Yeah.
so the SEC found the company's owner and former CEO guilty, along with several top executives. The SEC fined the auditors, Arthur Anderson again, over $7 million. And the base
Hold on, this is the same Enron you talking about with Arthur Anderson?
No, these are the
No, that's
people
not
who
the
are
different
part of it.
company. Right, these are the auditors.
What your screen look like what you're reading from?
What you mean?
I must see, open up.
Accounting scandals list and overview.
Do you mean the waste management? That's where we is now?
Yes,
That's-
waste management scandal, 1998.
Okay.
That's the first one. The second one is Enron, 2001. We just
Mhm.
read about that.
Oh, okay, all right,
Then you have WorldCom, because I mentioned
Okay.
WorldCom in my notes.
okay.
WorldCom was an American telecom company in Virginia, 2002. Just a year after the Enron scandal was discovered that WorldCom had inflated its assets by $11 billion, making it by far one of the largest accounting scandals ever.
So Arthur Anderson, he in jail, eh?
That's a company.
But I
That's a
mean,
com-
if that's 1998, then again in 2001, like what's going on?
What you mean?
That's the same company.
Yes.
So
They
why
just
would, like, how come they still was operating after that?
It takes a while to investigate,
Right.
you know. Investigation is not overnight. And while they're being investigated, they're still in operation.
And you're still doing garbage and you know you didn't bring
Mhm.
somebody down?
So
I
listen.
mean, I guess by that point, it was understood that they were on the take. And so, you know, big companies sought them out. You want to do some things, talk to what these people name, and they'll help you out.
Well, look like Arthur Anderson and had no good corporate governance neither.
Okay, so listen, Arthur Anderson goes out of business. This is 2002. 2002, they went out of business.
Millionaires, eh?
Very reading.
Why you worrying about how much they made?
Yeah, everybody making money around here. Yes.
Oh Lord, let me read it to you so you can hear what Arthur Anderson. See why I'm gonna make this a question? It is so exciting.
What is the question? What is the question again?
Makita, please stop. I haven't formulated it yet. After 89 years in business, Arthur Anderson LLP on Saturday ended his role as auditor of public companies. The Chicago-based company was convicted in June of obstruction of justice for shredding and doctoring documents related to Enron audits. Didn't I tell you that?
Mhm.
Afterward, Anderson told the Securities and Exchange Commission it would cease auditing public companies. It already had given up its license to practice in several states. So, quote, as of this day, Arthur Anderson LLP has voluntarily relinquished or consented to revocation of its firm permits in all states where it was licensed to practice public accountancy with state regulators. The company now has fewer than 3,000 of the roughly 28,000 employees it had before the Enron scandal.
Jesus.
Of its more than 1,200 public company audit clients, none will remain.
Wow.
The firm's startling decline has come in less than 9 months. Its human resources director for Anderson said, it's like a family member who has terminal cancer. we're watching the firm die. As people have left and files have gone into storage, the human resources manager said Anderson staff members have removed papers from offices in a downtown Houston skyscraper and turned off the lights, leaving only furniture and artwork. Office supplies were donated to charities.
Wow.
And Anderson has had to disconnect his email system, overhaul his conference calling operations to take into account offices that close, and sell computers and other hardware. The once mighty accounting firm is expected to be sentenced on October the 17th.
Look how they run their granddaddy firm into the ground. 89
They were
years,
on
like
the
come
take.
on.
89 years.
They were on the take.
So what does Thingham, does Clico go into this?
No, no.
Totally different.
No.
Mm-mm.
Totally different.
So go back, let's go back to our 10. So WorldCom is 2002. Then you have Tyco.
That
So
name sounds
discovered that the CEO and the CFO had stolen over $150 million from the company
What?
and inflated the company's earnings by over $500 million in their reports. They had siphoned off money using unapproved loans and stock sales.
So why these things don't happen in this country?
They
They-
do. They
they-
do.
Hold
It-
on. I don't mean the action. I mean,
No,
Like how
they
these-
do. They do. And the problem with us is until very recently, say in the last 5 to 10 years, it's been quieted. So it never came out to public so as not to embarrass the company itself and so as not to take away from the public's confidence in the company itself. I know of one, I can call the name and you'll know, PricewaterhouseCoopers, very big scandal.
what happened with them?
One of their partners siphoned the monies and he went, because they hushed it up and he went very quiet. Recently, he was asked to do something with government and then that became an issue and he was again quieted.
Hmm.
It happens. And then you mentioned Clico.
Mhm.
I think in our country, because we're so family oriented, we're such a small island nation. The practice was you'd never see someone from Royal Bank of Canada going to jail for stealing by reason of employment. You'd never see someone from government going to jail for stealing by reason of employment.
Well,
It would be
we
quieted and it would be dealt with on the side. Public never knew about these things.
Yeah, in the past, but
in
not
the
now.
past. No.
That person will get that 2 years. That was something small compared to what's been allegedly going on.
Yes,
I
yes.
I think what happens in those instances, I can tell you definitely like the UB situation. There's quite a bit of siphoning going on and it happens at the very top level because if you think about it, these people who we see going on the television and going before the courts, they do not have the power to sign documentation or authorize payments, which means you need to get help from the very top or from the signatories. And so you have the scapegoat who is caught red-handed or who has to go to jail so that the people who really have the influence can get away. We still have the I know you, you know me, and I know what you're doing, let's leave that alone kind of situation.
Mm-hmm.
And unfortunately for this young man, he carried that cost.
Yeah. So look at Health South.
That's a high cost. His parents cannot get over that yet. And I'm feeling that weight with them. What are we looking at, Miss Archer? Health South.
Yes, the next one. Yeah, I don't know how he did it either. I read it. I don't understand why would you do that. But anyhow.
No, Miss Archer, you understand why he did that.
Yeah, but
It wasn't really for him. It was for his aunt.
yeah, but why?
No, it's okay. Here's what it is, really. Here's what it is. My aunt puts through an invoice. Whether it's true or not, I receive an invoice for work that was done. And because she's my aunt, I push it through for her rather than her having to wait the 3 months and the 4 months it takes for government to pay out.
Agreed. So how did the price get inflated?
She put through her invoices. Now, I don't know what your invoice is supposed to look like. You submit to me an invoice for 200,000 and you say, I did the work, I need to get paid. I don't know that you didn't do 200,000. I didn't know that you didn't do $200,000 worth of work. And particularly if you have a contract that is signed off, there's some stamp on it. I simply put through your paperwork for you to get paid. And auntie, you give me out a little piece of money for helping push that through faster.
But that's negligence on his part.
Exactly.
Here's my thing. The young man has no power to sign any checks or make any pay order.
But he got something from it though. But he got something from it.
You got something from it. I agree. But the thing is
right there.
Yeah, the thing is this, and they can't find the aunt. Nobody can find her anywhere, nowhere in Nassau.
What? There's a pandemic.
That's a serious situation. Nobody can find Auntie Darius. But the thing about it is, Auntie Darius didn't do this just to him. She didn't just do this to him. Auntie Darius, because of your job title, brought in things or had things brought in through you for other people. And where a person is supposed to get a box valued $50,000, when they open their box, they're only getting $25 worth of stuff.
Oh, good God.
This goes a lot deeper than what was said on the television. This goes very deep.
Will they find the auntie who's supposed to paint the stadium?
Auntie can be found.
How is that possible?
You leave town?
But you should be on somebody manifest.
So she gets tip off it.
Well, it depends on how it depends on how you do it, Miss Archer. How you can actually get into the States without taking an airplane.
Yes, I know that.
Okay.
Well, anyhow, they'll issue a all points bulletin. Send it through Interpol. They'll find out.
But the unfortunate thing is this young man's name has already been called. He's already been paraded before the courts. His life as he knew it and his family's life have now been stained. Why would you put your own nephew through that?
Yeah, but why did he admit it?
You know who he is and who his family is. And he's, his lifestyle says, I made a mess. I did something and I'm copying to it.
But you heard his family.
It hurt his family. Lord have mercy. Okay, let's move on.
Health South. Health South was 2003. Because Marquita, she says hell bent on these auditors. So let me see. Health South discovered that the company had inflated earnings by over $1.8 billion. The SEC had previously been investigating Health South CEO Richard Scrucci after he sold $75 million in stock a day before the company posted a huge loss. After the charge, Scrucci was acquitted of all 36 accounts of accounting fraud. However, he was found guilty of bribing then Alabama Governor Don Sigelman and was sentenced to 7 years in prison.
That is just the alternative way of catching him.
Yes. Freddie Mac. It was discovered that Freddie Mac had misstated over $5 billion in earnings. COO David Glenn, the CEO and the former CFO and the former senior VPs had intentionally overstated earnings in the company's books. The scandal came to light due to an SEC investigation into Freddie Mac's accounting practices. The same 3 gentlemen were all fired and the company was fined $125 million.
Wow, they were fired after.
Yes.
Okay.
AIG was in 2005. It's an insurance company with over 88 million customers across 130 countries. They were found guilty of stock price manipulation. The investigation revealed a massive accounting fraud of about $4 billion. Found that the company had booked loans as revenue in its books and forced clients to use insurers with whom the company had pre-existing payoff agreements. The company had also asked stockbrokers to inflate the company's share prices. AIG had to pay $1.64 billion in fine. The company also paid $115 million to a pension fund in Louisiana and $725 million to 3 other pension funds in Ohio. Then, of course, everybody knows the Lehman Brothers scandal. You do, right?
Mm-hmm.
Okay. So that was where in 2008 financial crisis was discovered that the company had hidden over $50 billion in loans. And these loans are being disguised as sales using accounting loopholes. They sold toxic assets to banks in the Cayman Islands on a short-term basis. Lehman Brothers would buy back these assets. They gave the impression that the company had $50 billion more in cash and $50 billion less in toxic assets. In the aftermath, Lehman Brothers went bankrupt. So you know Bernie Madoff, they even have a movie on him. He orchestrated the biggest Ponzi scheme in history and also one of the largest accounting scandals. Bernie Madoff ran the Madoff Investment Securities. After the crisis, it was discovered that he had tricked investors out of over $64.8 billion.
But just do it all that money.
He's in jail now. You should see his lifestyle. Look for the movie. Madoff, his accountant, David Freeling, and second in command, Frank DiPascali, were all convicted of the charges filed against them. The former stockbroker received a prison sentence of 150 years and was also ordered. He was ordered to pay $170 billion in restitution.
Oh my God.
Life. Wow.
But there is a movie on him. The Stadium scandal in 2009. This was an Indian IT services and back office accounting firm. In 2009, it was discovered that the company had inflated revenue by $1.5 billion, marking one of the largest accounting scandals. An investigation revealed that the founder and the chairman had falsified revenues, margin, and cash balances. And during the investigation, he admitted to the fraud in a letter to the company's board of directors. So although he and his brother were charged with the breach of trust, conspiracy, fraud, and falsification of records, they were released when the Central Bureau of Investigation failed to file charges on them. They got away scot-free.
Really?
Wow.
Yes.
With money then?
Huh?
With money.
Yes, they did. So that's good. This you could look up. I'm gonna see if I can. I'm thinking about it. I'm thinking. I could use these. Anyhow, let's move on. I digress.
Miss Arch, you like to put cheeses in here. I realize that now.
I swear,
Like what?
that.
I realize that now. Okay.
No, I like to tickle your brain. You should be saying, oh my God, look at these scandals. What happened? Oh, what did the directors do wrong? Which duties did they breach? How could things have been done differently? Why didn't they recognize it? Why were they doing it? There's so many questions.
Because plenty of people is getting paid off.
Yeah,
Not just set who names get called. You can't be doing that by yourself.
Yes, but the thing about it is when it comes to suing, it comes down to those who have the fiduciary duty. They have a duty to the company.
Directors, okay.
Right. So even here with the matter what we were discussing earlier, and like we were saying, there are other people who are above them who are signing things. They also need to be accountable. And we don't see them going that far. They're only going as far as the persons who would have taken the money, spent the money, so they bring their money laundering case against them. But they're not going behind how did this happen in the structure itself. Someone else is responsible. But they're not going that far. So officers, the general statutory duties do not apply to managers who are not directors of the company. But the courts don't distinguish between the actions of a director as director and actions as a manager. So
You
whether
mean if they have the same capacity, you mean?
the director, whether director is an executive and he's a manager, there's no distinction. He still has a fiduciary duty.
Mm.
So some actions by senior management of the company, provided they are also directors, will be subject to the controls of the general statutes, which means they have that duty of care. So in addition to the company directors, you have officers, and they carry out the operational and the daily mandate and activities of the company, and they oversee the supervision of critical corporate duties and responsibilities. So what is really difficult, not just here in the Bahamas, but you can see from these various scandals, is a lot of people, directors and officers, do not realize that they have a corporate responsibility and they have duties and responsibility to the company. And like I was saying to you earlier, a lot of people who are directors and officers don't understand what is a conflict of interest. So officers are normally answerable to the board of directors of the company. So if you look in the Companies Act, it says officers is defined as the chairman, the deputy chairman, the president, the VP, the managing director, the general manager, the controller, the secretary, or treasurer. Okay. And then it says any other individual who performs for the body corporate functions. So normally that's why you see, depends on the company, they use these words interchangeably. So there'll be chair, deputy chair, or they call them chair, vice chair. Then you have the president, you got a vice president, managing director, general manager, CEO. They just use the words interchangeably.
What section you in the Companies Act?
When I wrote this, it won't be on your consolidated. It should be officers defined under section 2 of the Companies Act. Then you go to section 115, maybe different in your consolidated. It says the directors of the company may designate the officers of the company, appoint as officers persons of full capacity, specify their duties, and delegate to them powers to manage the business and affairs of the company, except powers to do anything except the powers designated in section 103. The director of a private company may be appointed to any office of the company, subject to section 85, subsection 1. A director of a public company may be appointed to any office of the company, and 2 or more offices of the company may be held by the same person. And then I gave you the citings under the IBC Act.
I'm just gonna write it down. I can't find it.
What do you mean you can't find it?
I look and I am 151 now. I don't see.
You want the consolidated.
But if you read, if you're on unit, what is this, unit 6? It's at the end. It's unit 7. It's at the end of unit 7, just before the assessment questions.
Exactly. Then you have a standard of care. Every director, officer, agent, and liquidator in performing his function shall act honestly and in good faith with a view to the best interests of the company and exercise the care, diligence, and skill that a reasonably prudent man would exercise in comparable circumstances. So in the beginning and in the middle of this presentation, I told you that those are statutory requirements and common law. And now you see that in the Companies Act, it actually states the same thing. So it's enshrined in our law. The fiduciary role, duties, and responsibilities of directors and officers in the management of companies are significant and pervasive. The challenges of good corporate governance, increasing shareholder rights, improper actions by directors, and the pervasive legal liabilities of risk exposure to directors for the performance and propriety of companies make it more challenging for directors to clearly define their roles. in this ever-changing environment of modern commerce. Recent cases has reflected that the ambit of directors' fiduciary duties extend also to shareholders, creditors, and employees of companies, making the expectations, responsibilities, and accountability of directors that much greater and more demanding. So these duties are important reminders to directors of their need to be prudent, proactive, and precautionary in their roles as executive and non-executive directors, whose decisions and actions are increasingly under scrutiny by the stakeholders, the courts, and the public at large. Isn't this a wonderful unit? I just love it. What happened? Why you all have these funny laughs?
That don't sound right.
This is wonderful. What's wrong with it?
I just reached in. It sounds like that's an exam question.
Of course it is. You can't miss it.
Okay, so back to that structure. Now, remember we was discussing with this unit 7, but this is going to be on the final then, because the
Yes,
midterm is
final.
supposed to be, okay.
It's final. It's the final. It won't be now. Yeah, okay. I'll just have to figure out how I'm going to word it. It's coming. All right, let's go to our questions.
Oh, yippee.
You know, Makita, she want to stress me to death now.
I ain't trying to stress. I done stressed out enough. I can't even help. I just stress.
Okay. So I sent you some questions. Let me see where I put it. Not there. But I put it in here. Have a look. Let's see who wants to attempt question number 1. I like to put fill in the blanks, you know, if you like
That
that.
is, yeah, that ain't cool, because this is,
I like fill in the blanks. Who want to try number 1?
These from the last unit, right? The last class. right?
Yes, yes. Remember I said, because you always just wanted to just carry on, I said we will do some questions, which I know you all are excited to do.
Oh,
very much.
Okay. So who's going to try number 1?
Like all of the blanks?
No, okay,
Have to
okay.
ask.
Okay. All right. So let's be fair. 1 blank each.
Let me get me to the first one.
Okay. How we laughing?
Me, Katina.
My first blank is the agreement of the shareholders.
Eh,
No?
no.
No, I
Next
gotta
question.
The
Next
rights of the
person.
shareholders,
Yes, that's correct.
What it is, the
Wow.
what?
the rights.
So that means
Oh,
I put number.
why? You know, I said, I thinking about this unit when you was talking about the agreement.
Oh, okay.
God. Okay, unit 6, sorry.
Who's doing the second blank?
You said the first one was what, sorry?
Right. Sometimes
The
you
right,
ask that.
sorry. Look, I have a lot going on.
Who's doing the second blank? Let's go. Anybody?
Second blank is right.
Yes.
So the rights and the right?
Yes. The rights and the rights with an S.
Okay.
Okay, let's go. Next sentence.
A company is a separate legal entity.
Okay, separate legal person.
A separate legal person. It
Okay,
follows that the rights of the creditors must be met.
not
from
rights. No, not
No,
right.
liabilities.
The liability. No, creditors don't have liabilities. You are liable to a creditor.
Okay, and
That's
so
right.
what's the word?
The expenses.
No,
The debt. No, it isn't a debt.
not that. You all know the word begins with C.
See.
With a sound or sound.
A what?
Contributions?
No.
Is it the
C.
contract?
That's the shareholders. Oh,
Is it the contract?
No. 6 letters.
Oh, Lord.
What is the sixth letter?
S.
That wasn't helpful.
But you asked.
creates.
I say 6 letters. No.
What is that? The no.
I should give y'all some of this on the midterm.
No.
No.
No,
We
no,
are
thank you.
seriously
No, thank
having a
you.
midterm?
Y'all loving this.
No, are we
No.
seriously having a midterm?
She
Who
wasn't
asked
here.
that?
She
Where
wasn't
were
here.
you?
Who
She
asked
left
that?
early that night.
I'm about to write that, you know. They agreed for a midterm.
I'm about to bow out of this class. Honestly, I can't do a midterm and end of no.
No, listen to how she broke down the midterm. It isn't bad.
Man,
Really, it is.
It's a take-home midterm. And
I
we have
can
6 days to do it.
okay.
And it's on the
And it's
first 5
based on the first
chapters.
5 chapters,
And so which means the finals will be based on chapter 6 to 10.
excluding 9.
Oh, glory to God.
So we're all in agreement with that, since you all digress again.
I'm not in agreement. I am not in agreement, Ms. Archer. I'm not.
Okay. Well, hold on. More people on than when we agreed. So y'all come to consensus after we finish this Q&A.
Okay, you won't give us the answer to the other one.
I mean,
It
none of y'all.
starts with- it
Six
starts
Read the
letters.
question again.
ends with a S.
A company is a separate legal person. It follows that the blank of the creditors must be
Left from the blank.
6 letters. C is the first letter, S is the last letter. Want me to give it to you now?
No.
Okay.
Hold on.
What is wrong with me?
What? You can't remember?
I know this. And
I
I'm
know
gonna
you know it.
piss when you give the answer.
You ready for the answer?
Yeah, we taking too long.
Claims.
OMG.
Oh, wow, Jack.
Okay.
Yeah, wow.
So a company is a separate legal person or entity, if you want to say. It follows that the claims for the creditors must be met from the
Company.
From the
company's
assets.
company's assets.
Companies.
Assets. Next blank.
Capital.
Yes.
It got one right.
The shareholders' capital contributions. Next blank.
Contributions. Blank, the blank to which creditors are exposed.
Mm-hmm. Let me know.
Cover the liabilities.
Mm-mm.
create the, no,
Okay, the first blank begins with M.
The capital contributions.
8 letters. Begins with M, ends in E. 8 letters.
Mitigate?
Yes. The blank.
Risk?
5 letters. Yes. Mitigate the risk. See how easy that was? I can give you up at 5 of them.
No
Five
job.
what?
No job.
No, that ain't no that ain't thing that ain't.
Oh,
I
job.
remember, I recall, and that was some years back, and the students, they argued. We want multiple choice and fill in the blanks and only give us 3 essays. Oh my God.
I want to fill in the blank. Just saying.
No.
Okay, if you all say.
Mm-mm.
Okay, let's go to question.
I was right there filling in.
Let's go to question number 2. When is a share allotted to the investor?
When he purchases.
You mean if he trades?
that's
If he-
usually at an IPO or, when the company is looking to increase its assets, its capital, its share capital. Oh,
So notice the words is allotted. When is it allotted?
If it's bought.
when they buy it,
When you say buy it, what do you mean?
If when the person buys, when they buy a share, they become a shareholder.
But they don't have to buy it if they provide like a service like the building or property. No, property was the only one that they could provide. Some
Listen, it's an interest of the buyer, right? The share.
Mm-hmm.
And so if it is bought, then the person that buys the share becomes a shareholder. So the investor becomes a shareholder.
But when is the share allotted?
When it is offered.
Okay. So it's when it's offered to them. So when is a share issued to a shareholder?
Upon agreement of the directors.
That's not the last step. What is the last step in that process to be a shareholder? Someone said something just now.
resolution.
No.
When you get the share
When they
certificate.
receive a share certificate, yeah, that's what I want to say.
No,
Then
the
no.
issue. When it's issued. And it's by resolution, and then there's the issuance.
One more step.
Consent agreement? No.
No.
Hold on, the step comes after the resolution, you said?
When it's ratified?
No. E.
Oh, gee.
Extraordinary general meeting.
No.
Received.
No. REG.
Registered.
Yes, when it's registered in the register of members.
Okay, so
that is when it is issued. So that's normally why you have the certificate has like today's date, and you record that in the register today's date. Then the share is issued, technically in company law.
So when is it allotted, you said? What happens?
Allotted is when you come to the agreement that you want to buy these shares. So there's a contract to buy shares, or there's a contract from the company to sell you these shares. So there's an agreement between the two parties. So shares being allotted to you.
And when
But-
it's issued, you say it's when it's
On
placed on the,
when you actually put it on the register of members. I should have leave that for the final exam too.
so when it is placed on the share register.
Yes.
So put it there, Archer.
Hmm?
I said you could still put it there. At least we'll know that's and we'll know that's one question we'll get off.
That's right. We'll be ready for that one.
I listening to you all, really funny. Who wants to stab at number 3?
The liquidator come after the shareholder for the value of the non-cash consideration.
No. I think no. I read this, but I don't know why I'm saying no, but I'm thinking no, I could be wrong.
Mm-hmm.
Because it's not fully paid up.
As money worth, non-cash consideration, can a liquidator come after the shareholder for the value of the non-cash consideration not fully paid up in a case of insolvency? No, because it's a non-cash consideration. The
Mm-hmm.
liquidator is looking for something of value. To pay the company's creditors. So I know this, I'm doing a liquidation right now.
Okay.
Green. Non-cash consideration, can it? Is money worth a non-cash consideration? Can a liquidator come after the shareholder?
But you
What
only liable for what you
I take that back.
what you put in, right?
Oh, she's taking something back now. Hold on.
Yes.
Go ahead, Makita. Y'all tell me.
I thought that you're only liable for the amount of shares or the amount of worth of the shares. So if it's non-cash, hold on, sorry.
But being non-cash does not give it non-value.
Exactly. That's why I took my answer back.
Yes.
But it still say not fully paid up.
Doesn't matter.
Good night.
Doing good night.
Sorry, I was telling my mother, I'm sorry, it's
Oh.
the problem with being on these calls when you're at home, you also have to deal with house. Okay, sorry.
Yes. So what's the answer?
It says shares are also allotted for cash when the company is indebted to the shareholder and they agree that the debt will be discharged by crediting. The answer is yes. The liquidator can.
Yeah.
After
Yes.
the, huh?
Yes. My answer is yes.
It says that it is unusual for there to be any unpaid amount on share issued for non-cash consideration. But
Read
in the
that again.
unlikely event that coming to pass, such as in circumstances where the non-cash consideration is an as yet undischarged undertaking to transfer something or to do something, and does not fall into the categories of things which are deemed to be cash, the liquidator would have a right to make a call for the unpaid amount. Do we agree on that one?
It
Which
is,
page
yes.
this was? Where you got that?
Where you reading?
Don't worry about where I'm reading from. I'm about to tell you what the law says. So,
Sorry about that.
so where a private company issues shares for non-cash consideration, generally the court will not examine whether the consideration is adequate, provided that there is a valid contract of allotment made by the company which stands. However, shares must not be allotted at a discount to their nominal value. So in the case of Rang, which was a court appeals decision, this is about a private company that had share issues for non-cash consideration. And here the liquidator sought to show that the value of the business had been overstated by some 18,000 pounds. And he claimed either to be entitled to treat the shares representing this amount as unpaid, or to charge the two directors with malfeasance in connection with the purchase. But both claims failed.
What's the name of this case?
REWRAGG Limited, 1897, 1 Chancery 796. In this case, the judge held that the transaction was wholly legitimate, and he noted that Oregon Gold Mining Company of India versus Hooper decided shares cannot be issued at a discount or below their nominal value, and then he gave his citation.
So in non-legal terms, not terms, language, plain English, what's the answer?
In this instance, he could not. What he said is, you look at the contract. He says the value paid to the company is measured by the price at which the company agrees to buy what it thinks it is worth to acquire it. So while the transaction is unimpeached, this is the only value to be considered. This is a contract between the company and the
value
investor.
that's in the contract.
Yes.
So, but for your number 3.
Yes.
I noticed that question mark is really big on that.
What I have to do with the computer?
I just can. Can you just, break it down in layman terms? The answer for that, number 3.
It can be yes and it can be no.
So it depends. So
It
also
depends.
you could answer yes or no and just bring a case.
Yes.
Oh, so we have to state the case, but how do we know all of these cases though, Miss Archer?
It's at the end of each chapter.
Okay, we go to the end of this chapter.
Oh Lord.
Oh, sorry, what was the case you use in reference again?
So basically when you I guess you did say that before, when you answering, if you can back up whatever your answer is, then it's just fine. Just be fine. Okay.
Oh Lord, I just can't take it.
Take what? You see, remember, Jessica, I was telling you, if a company does whatever it's doing, whatever transaction, if it does it honestly, and it's given the fair value, there's nothing wrong. There's nothing wrong with a person selling property to a limited company for fully paid up shares and making a profit from it. There's nothing wrong with that. So for a liquidator to go behind it, he has to be able to prove that the consideration given is impeached. That's what he has to prove. So it's really the value paid to the company, and that is measured by the price at which the company agrees to buy what it thinks it is worth to acquire it.
Mm.
Question 4. Who's attempting? Who I have not heard? Who's fire tablet?
Katina, I got knocked out.
Oh, okay.
Yeah.
Number 4 is for you.
Okay. The Articles of Association didn't make provisions for it. They just agreed that the preference shares would be paid out first in the event that it be wound up. The article is silent on it.
So what do you do when articles are silent?
Go to the act.
Go to the act.
But I didn't know the articles had to state that that's the deal with the preference shares, that they get in the event that it's wound up, they get paid out first, and then the ordinary shares get paid afterwards.
Mm-hmm.
So why should it state that when that's what it is? I
Yeah,
thought
but
they would state different if it wasn't, if it's in the contrary.
But it says that the articles is silent on how to vary the class rights. So where do you go for variation of class rights?
In the schedule?
Variation is also in the act itself proper. And then you supplement it with what's in the schedule. So it asks how it may convert its preference shares into ordinary shares. How can they do that?
They could do it with the shareholders' consent.
Mm-hmm. And then what else? Does it affect the other? By them converting the preference shares to ordinary shares, do they have to consult the ordinary shareholders?
Yeah.
Will the variation impact the ordinary shareholders?
Yeah.
Right?
Yes, they'll have to speak to the shareholders in that class to get their consent in order to do it.
Exactly. See how nice that question is?
That's not nice.
Yes,
Right.
it is. What's wrong with it? It said advise the company whether it can convert, and if your answer is yes, how to do it. It's a very easy question. Okay, last but not least, question 5. I hear no takers. Let me find somebody.
I read in.
I read into it.
Yeah, right.
Will I regular my answer?
T-Soul M share certificate.
2 sentences and you're still right.
So, okay, so we did this one earlier. And
Bona fide purchaser.
so you said because B
from the company
was a bona fide purchaser, he didn't know what was going on.
What was discovered and the company refused to register C.
Hold on, someone's still reading.
Yeah, yeah.
Legal system M, C, and B.
I think I should get Christina to do this one. Is Christina still on? No.
I think M is entitled to the value of the share. C and B are bona fide purchasers so that a chancellor starting at equity regards is done what ought to be done. Sorry, I was answering from a lawyer's standpoint. I apologize.
Let's go, Makita. Since she had tried to attempt that, I thought Christina was on. I don't see her.
Because B was a bona fide purchaser, and didn't have any knowledge
Mm-hmm.
that there was fraud involved.
They're innocent.
He's innocent.
Mhm.
Mm-hmm.
So it can't be reversed as to say there was in the fraud, so give me back my stuff. The company, the share certificate was owned legally by B.
Right. And what
So
about
he-
C?
When he sold the
C is
shares,
also
C can't get anything. B should sell it back to him.
C bought a stolen ship, bought stolen goods. So for him,
no,
it's
not
not bona fide.
knowingly.
But he didn't know. He wasn't
he
aware.
shouldn't have bought
Knowingly or not, no, even if he's not aware, he bought stolen goods.
So B still bought stolen goods.
Yeah.
No, B received a transfer, not knowing that it was B received a transfer. He did not pay money for it.
Same thing. The
And
transfer.
so if we had to look at who's going to jail, M is going to jail, C will receive a fine.
No,
How C can receive a fine?
C is also
Because
innocent, and
because-
so is B.
Because C has received stolen goods.
There's an
He's
exchange
No,
of
that's
money.
not considered serving stolen goods because B was innocent.
I didn't say what is not considered stolen goods.
The share is stolen regardless, but B didn't steal it, T stole it.
Exactly, and so C is simply not going to get the share. It can remain B's share.
But B got it from,
But
B
M
is
going to jail.
responsible for it.
M going to jail.
M,
B
it was
has
stolen
shares,
from
and
M.
C don't get
M
the.
going to
M
jail.
was
They don't get
M.
No,
Yeah.
M is the victim.
share
M is the
was
victim.
stolen.
M is the
Oh,
victim.
M is the victim. Yes,
M
you're
is the
right.
victim.
Right.
So
you-
M
I
should be
think
able to get the value of his
M
shares.
should get his shares back.
It should be given back to M.
Mhm.
So
M
here,
should get his
okay,
shares back. C shouldn't get anything.
and B should return the monies to C.
Oh,
Yes, that's how I feel.
Yeah.
And T should go to jail, even though she didn't ask him.
Oh
Well, let me hear Makita say it now. This was her attempt. Come on, Makita.
I'm just listening at this point.
No. You may find us on the exam.
Oh, goodness.
Really?
You know
I don't
T
know.
stole it. First thing you have to identify the players.
Uh-huh.
So T stole it
Mm-hmm. T stole it, transferred
from
it.
M.
Yeah, and transferred it to B.
Mhm.
Now, it says that B was a bona fide purchaser. So to me, that's telling me that B still paid for it.
No. Not
So
So why
necessary.
say purchaser?
I can transfer you a
No.
share without you paying for it.
No, you're saying how it was worded to say a bona fide purchaser. So I was saying.
He didn't know it was stolen. He actually
So
thought that T owned it. That's what I mean. He didn't know it was stolen. He had no idea. He thought that T owned it.
So then when B sell it to C, that still was legitimate money for him.
Yeah.
Yeah, because
Because
B
he legally
actually
owned
had
the share.
don't forget, B
Right.
actually had the shares registered. When you see that word registered,
registered.
Mhm.
and he
That
got a
means
new
it belongs to
certificate,
you
so
at that point.
it belongs to him.
Yeah,
Mhm.
Right.
he legally owned it at that point.
But
Yes.
the thing is, too, B had that registered when it was supposed to be M's certificate. So something had to gone down there.
No,
What do you mean?
understand? It said that he forged the transfer. So once that transfer is registered, it now belonged to him, regardless of how he received it.
He didn't know it was forged, Makita.
Okay. So then
He had
later
no idea.
sold it to C. That money legitimate for B.
Mhm.
So C is innocent, B is innocent, and M just get the shitty end of the stick.
Oh Lord. But they said the company refused to register C. Can the company refuse to register C?
No.
Where
No,
does it
no.
say that? Oh, yes, I see. Okay.
Yeah, it's right there.
Okay.
No.
So But the shares stolen, so why can't the company refuse it if the shares
Because
initially
C
They've
it was
already been
stolen.
registered from B.
Is
It was
already
already
registered?
registered legally.
No,
Okay.
understand now. C, I don't understand why the company is refusing to register C, because if it was sold to C, C should then have some certification that says I received this by order for sale. I paid for
do have
this.
it, but after the company found out it was stolen, that's where the problem was created.
But it wasn't
But it
created
still was
for B
already
or
legal.
T. It was created for T. Because they discovered that T stole it. So the company should go after T.
Agreed.
Agreed.
Okay, a share
They
is an
cannot
item
now refuse
of
to
property
register a share
which
certificate
can
to
be
C who was
transferred by
innocent.
sale or gift. Right?
So once
So-
they already registered it, it was legal.
Yes.
Yes.
So B sold a legal item, however you want to put it, to C.
So all in all, the company should register the share.
Yeah.
Yes. Apparently, I'm guessing that at that point it realized the fraud.
Mm-hmm.
And as such decided, okay, I can't, because it will continue to be perpetrated if they registered to C, and then C went ahead and sold it for profit again, and it would have continued to perpetrate.
Keep going on and on and on and on.
Right.
Right.
So they had to put an end to it. Now I could see the company saying, no, they refused to register it to C. However, C could purchase share. A legitimate share and cancel the share and
But it
cancel the
was
share
legitimate.
that was stolen.
Mm-hmm.
The share was registered, so it had to been seen as
They'll have
legitimate.
to cancel the one that they gave the B.
Yes.
Mm-hmm.
That's to cancel that. And either it is that B would give C the money back, or give the
I think
new
I have one.
share, the newly issued, huh?
You think B will give that money back to C? I don't think so.
Or give the newly issued share to C.
So if they give the newly issued share to C so they can stop the perpetration of the fraud, what happens to M?
I don't know what happens to M. Does M receive the right to that? I don't know if M should receive the right to that share. The thing though is once, that's messy.
Yes.
So
Because by
but
right,
They would
C,
have to reissue him a share.
but that'll be a loss to the company.
Yeah.
M gonna have to sue T for his share, for the value of his share. Bang.
So what if the new share, what if B?
I just want to witness all this on this certificate.
Anything beyond M, for me, anything beyond T suing M for the value as a share and whatever future law value it had will cost the company, and the company still is innocent too, along with B and C.
But then C, I guess if they cancel B shares, if they had issued another certificate, can they do that?
What if they issue bonus shares?
I wouldn't do that if I was the company. You costing me. I'd fire the board of directors.
Somebody's
how-
head will roll for sure.
Yeah. Because M wants a share certificate.
Exactly.
But that's what I'm saying. You can't cancel the share certificate that B got.
You can't, because is innocent. B is an
He's
innocent.
innocent.
No, I don't mean as in, okay, I guess what I'm trying to say is that the certificate that B got can be changed to another number, so that when C get it, it wouldn't have been the same one from M, since we know that it was.
No, he got a new one, B got a new one. Read it again. B
A
registered
new
and
share
received a new
certificate from the
certificate.
company. Yes, he
Right.
received a new share certificate from the company. So the share certificate he received was legitimate.
Because it's now in his name. It won't be the same certificate number 005. He may have certificate number 010, but it's in
Okay,
his
so
name.
005 is then what?
That was canceled.
Mm,
The thing, well, I guess that he must have been a really good forger.
Yes, of course. Plenty of them around here. So what happens to M?
M loses the value of the
and
shares.
have any insurance or anything on the shares?
Likely
go
not.
sue T.
This wouldn't be like a
M
court.
loses the value of the shares, and unless he sued, like you said, unless he sued T, he can't get his money back, his rights. He's lost his rights to the shares.
Yeah, he loved to sue.
It's unfortunate.
Yeah. Because the first thing they're gonna ask him, if he wanted to go against the company to say replace my shares, he'll have to prove to them that he actually had that certificate in safe custody. And not lying around. How did he get it? Okay, and so if it's negligence on his part, he could forget it. Yep. He'd lose out.
Sucks if that was Microsoft or Apple.
Whichever one it is, he lost.
He lost.
Yes. Unless he can prove otherwise. Maybe he's seen Island, didn't remember where he put it. Or maybe there was a robbery and someone came into his house. He would still have to go behind the thief or the
forger.
The forger.
And what is the outcome for C and B?
C and B?
They have to register the sale to C.
Not necessarily. But they
Why not?
Yes, they're innocent.
They're innocent.
But it
Their
says here that they
transaction was honest.
refuse.
Yes, but they're refusing,
They
but that's
can't
why you're having the
refuse.
discussion. Because they can't refuse.
So C could sue the company.
Yes, he can.
Yes, he can to register the share.
He has a right. He has a right to have his shares registered. Because B was a bona fide purchaser. And they issued the new share certificate to him. They registered it. He is a shareholder. They should not have done it. They should have done their homework. So when that person walked in there, they say they purchased the stock, now they want it transferred into their own name, they should have done their due diligence. Wouldn't you have called the previous shareholder? Wouldn't you have gotten some documentation to prove?
Right.
It wouldn't just be the signature on the back.
Yes.
Right. It wouldn't be just a signature on the back. You have to match the signature, then you call the verify. And in most instances, depends on the type of shares it is or the company, you would actually call the registrar to say, I'm in the process of selling my shares. It depends, unless you have something on the stock exchange. You don't just go and do these things in private. And then afterwards, you want to haul a fraud. He could have exposed his certificate to the fraudster, bragging how he have shares. You know how Bahamians go. I have shares in this and I have shares in that. Oh, let me see the certificate. Let me see what it look like. And then watch and see you pull out the second drawer in the china closet. Well, I know where to go and get it. And it happens. And so Emma love the sue T, and of course he's not getting anything. So he lose out.
So sad, Mr. T.
Yes. No, for M.
Mr. M, sorry.
Yeah. He's lost. It's a lost cause. Oh, you all had fun. So I think I should do chapter 8, no, chapter 7 the same way,
Miss-
company
Miss-
You was a
management.
Miss
setup.
Archer, honestly, honestly.
I like you all to use your brain. Admit it, you had fun.
No, that worked me a little too hard, Miss Archer.
This whole exam should be open book.
I
I
agree.
agree with
But
you, Lisa.
hold on, wait. If that work you hard, what would you do in the company's department in a law firm?
I would not work in the company's department in a law firm.
Or-
First of all, I am an
or in a trust
accountant.
firm?
Oh, Lord.
First of all, I am an accountant
Okay.
who became an AVP of corporate. So understand, I have to do a shift in my way of thinking. I think in terms of numbers. Thank God my staff have legal brain.
Oh, isn't this fun?
Oh, wow.
Are we
Yes.
taking votes on open book then? No?
For what?
I
For the
love that
midterm,
idea.
of course. For the midterm, of course it is.
But to the AVP, now you know how to look at a legal bill and know when somebody's swinging you.
No, mind you, analytical because of the accounting. So I question everything. And
Okay,
what I do not understand, I say, okay, pull out the act. Is there something that the act says in that respect? But again, I think in terms of numbers first.
Okay, okay. But now you can apply your company law.
Yes, ma'am.
Yes. Okay. So I promise you on the midterm, man, Friday.
No.
But you were supposed to discuss this, you know. You all are not discussing that.
I'm hoping that we put a
Oh,
plug in on that
no.
midterm and say move toward end, period.
No, but it's supposed to be a take home,
It's
so.
a take home for 6 days
A couple
on
of
5
days.
chapters.
Okay, in that instance, okay, I could agree to that.
You'll agree
I
to
don't
that.
know if I want to agree to that.
Consensus.
It's a take home for 6 days.
If it's an absolute must, I would prefer not to.
They asked for it, you know. I didn't
I don't
ask
understand.
for it.
I really don't understand the people in this class. What do y'all do that y'all find the need to ask for work?
I'm trying to look in the book for the answers.
So you
Miss
tell me you rather
Archer?
have a final exam by Miss Archer, the way she words stuff, for 10 chapters rather than having a final exam on 4?
No, I prefer to have a full, let me just do the end and be done with it. I can't do this midterm. Listen here. No, honestly, listen here. I got home from work after 8 last night. I barely make it in for class at 6:45 each Tuesday night. Honestly, by the time I'm coming, I'm fried.
So are you gonna do the final with all them things on it?
I'm taking the time off.
I'm taking some time off to prepare.
I'm taking the time off to study. Yes, thank you, Lisa.
Me and you, you got my vote. I'm behind you. Solid.
Yes, ma'am.
Okay. All right, let me give you
I'm
an
in that capacity to
alternative.
take off work to go study.
Let me give you all an alternative.
Solid.
Why don't I give you all for midterm, since it's a lot of work? Why don't I give you all a position statement?
What's that?
Make a statement and you write me your views based on certain scandals.
Scandals, as in more than one?
Maybe 2. You can do 1.
Are we gonna be directed into where the statement coming from?
No.
Also, we just still gotta read the whole 5 chapters.
No. Scandals.
For instance, the 10
Right.
10 accounting firms that we did this evening, that kind of thing.
Yeah, but this wasn't
I
supposed to
want no
be.
more research and stuff.
That wasn't supposed to be on the midterm though.
I'm giving you an
missed
alternative.
that first half. I might have enjoyed that.
So what you're trying to say then is that the final exam will have all the chapters and the midterm will have whatever on the scandals.
Yes.
Hold on
but
one
don't
sec.
forget
Hold on
now,
one sec.
the-
Hold on one
hold
second,
on,
Miss
hold on,
Archer.
hold on,
Miss
hold on.
Archer. Hold on one second, Lisa. the Ms. Archer sent us a link to the 10 accounting firms. So once you go through and read through it, you'll get the gist of what we did it with that. We just read
Okay.
through to see what, and it fits with the unit that we did this evening. So you'll understand it with a read through.
Okay.
Please continue,
you.
Ms. Archer.
Okay, right. So I noticed, Marquita, you all keep saying the exam is on the whole, all the chapters. It is not.
The final one I talking about, I mean, if we just do this.
The final, don't forget now, the final, before you take the finals, I give you a review. So you know exactly where the questions are coming from.
Okay.
I haven't written it yet.
So we're still doing the capstone.
Yeah.
Okay.
But I could give you, like I say, for midterm, you could do one on director's duty. I'll see how to word it, and you pick a scandal and give me your views.
I prefer that. I prefer that.
So it's a good application of the principles of the director and his duties and what he's supposed to do. And I don't think that is too difficult because there are 10 there. You could pick one, whichever one you like, and you could answer the question I asked you. Maybe 2 pages long, maybe 3. There's no limit.
Where were you when I was in college?
How much is this midterm worth? Does it take a percentage from the final, that the 50% of the final is worth?
No. That's his own percentage. What's the percentage, Makita? She knows it out of her head.
Me?
Isn't it 20%?
I know.
Isn't that the front of the book?
It's in
I
front
only
of the
know.
book.
Right.
Okay. What are you asking? The final is 50%. The capstone is 30% and the homework is 10%, which I didn't do, but anyway. Class
Because
petition.
No, this is homework. Homework is what you're doing right now.
Okay.
the midterm wasn't inside that.
It's not in the course assessment.
Because
I thought the
There's no
midterm was gonna be
midterm.
half of the 50.
we asked about the midterm.
So the midterm isn't gonna be half of the 50?
No, the midterm was supposed to replace the 10% from the homework, and we weren't gonna have any more homework until the end.
Oh, I didn't know that.
Yes, that was agreed last class.
I thought
need
the
the
midterm was going to be half of
bring
the
down that
the
final.
percentage
No.
of the final.
No,
Half of the book, the first 5 chapters.
But when would this midterm be?
Friday.
Or why do the midterm? You said that the end of the class, the exam, which is 50, you give a review on what to study for all 10 chapters?
No, I just said it's not 10 chapters. I will decide
not-
which chapters.
She'll do a review, and based on the review, the exam will come from that. It's not necessarily chapter 1, 3, or 4.
Okay,
You know what I think the problem is? I think we're focusing too much on this exam.
Exactly.
It was
Rather
50%
than
of
trying
the
to learn the
grade.
topics. Because it was said last week, no more homework. So that research paper, you could take it for the 10%. You have the capstone, and then you'll have the finals. There's a review.
Can we just stick with that, Ms. Archer? Let's just stick with what was supposed to be. I mean, I think for persons who think that they need assistance and they come to you one-on-one and ask for additional work, then that's one thing. But I'm not prepared for a midterm. I'm sorry.
yeah, I say stick to the original. We were already doing homework anyway.
Yeah,
So-
and
so
you
much
just
more
finished doing
classes
homework
left.
just now again. Yeah,
The
and we
homework
just
has to
finished
study,
homework.
so
Yeah, okay. So I'll formulate a question to send to you all based on the scandals.
So when would this
That'll
be?
be the midterm.
That'll be
Oh,
the midterm in a week's time.
Okay.
And we're gonna do this in class?
What?
The midterm is gonna be during class hours, or just to take home
No.
still?
You take it home and you send it to me.
Okay.
so we doing the midterm again now? I thought, no.
The research
Yes.
paper, yes, the research paper,
So midterm, no homework.
no homework.
I write a homework.
Could you do it for all of us then?
So, Mrs. Archer, let me understand.
Yes.
So you've changed that the midterm will just be that one question on the scandals, correct?
Yes, just that one question you will have.
Okay, and that still means that will replace the 10% for the homework, so there will still no longer be any homework. Is that what you're saying?
Correct.
And then before the final, you will give us a review to tell us what specific chapters to study, because
Correct.
the final will not be on all chapters. You will specify which
Correct.
chapters. Okay.
Right. I'll even tell you in a roundabout circular way what issue the questions address.
Okay.
So you don't have to be going all over and read the whole book from page 1 to 100 and something.
Okay.
How far in advance would we get this review?
Where's my book? It's on the schedule. That's my interlude music.
Okay, so the final exam is supposed to be April 10th. It doesn't say when the review itself is, but I imagine that
On the
it'll be
last day of
prior
class.
to. Okay,
On the last day of class.
which is March
Remember, we
30th,
switched something
23rd,
because a date was
23rd.
missing.
March 23rd. So,
Mhm.
okay, what, the
Look
23rd
at
is the
us,
last
shiny
day of
yours.
class? Excuse me, the 23rd is the
Yes.
last day of class. It's not March 30th with company liquidations?
No, because the dates were wrong.
I understand. Okay,
Mhm.
thank you. I just want to put a plug in, Miss Archer, for a
Mhm.
note of sympathy that the 28th is my birthday, so I really don't want you to give us any work around that time.
28th of what? March?
28th of March, yes.
The 4th of April is mine.
And it's, oh, you Easter baby too. Okay. And you know, it's a big number, Miss Archer. It's a big celebration and a halfway year of life number. So let's be
Halfway of
kind.
life number? What is that?
50. It's the big F word.
You call that a halfway of life?
Yes,
Okay.
because by God's grace, if he does not come or call, I will live to be 100.
You really want to be that old?
Well,
Yeah.
I just want his grace to allow me to live until. How about that?
Okay, that's a
And
long
enjoy
time.
and enjoy life.
Okay, if you say so. All right, so let me just go over this now. We had agreed that on the 16th, the midterm would be due. Remember?
15th of March.
Yes,
On the what?
16th.
Of March.
Mm-hmm.
That's
So when
the
you
capstone is
send it to
due.
us,
This week.
The 16th of March is midterm.
Yeah.
The question will come to us this week and it will be due to, you should receive it by the 16th of March.
Yes.
Okay.
So on that day, on the 16th of March, because we're not doing an actual midterm with lots of questions, so we could still have class on company compliance. It will be short.
Okay.
It's a very short chapter, so it wouldn't take us long. So if you're not finished your midterm, you still have time to finish it up.
Okay.
Because I know time runs up on everybody.
Listen, March is here and we began in January. Who's to say?
Yeah.
So
So
when is
next
the
week,
capstone due again?
the day of the final exam.
Okay.
okay, so we getting the question next week and it's due on the 16th.
You get into question this week.
This week.
Oh, this week. Okay.
Don't forget that people are working and stuff. So if I send it like 2 or 3 days before, it's not fair.
No,
Yeah,
it's not.
I agree because
Right. So I
Yeah,
give
no,
you sufficient time. So there's no excuse for someone to say that, or they're late because of this, because of that, because you had sufficient time. And you already know now, between now and the weekend, you have time to look at the 10 scandals to see which one you really would want to do right on. See which one you can find more information on, which one you think you'll find interesting.
What is the
I think
midterm question
I think I've
again?
already chosen mine to be Enron, but okay, go ahead.
It's on company management, directors. Enron is a very good one.
It's a juicy one.
Yeah, it's a really good one.
Any particular points we have to mention, or like what exactly?
She will give you the
I
question on
will give
Friday.
you the question on Friday.
Oh, okay.
So we all on one accord now. We're happy.
Yes, ma'am.
And I have your permission to give you at least 5 fill in the blanks on the final exam. I wrote it down. You love it so much.
No, who agreed to
Could
that?
we answer it as a group during exams?
Who
What?
agreed to this?
No,
I'm being facetious.
I know you are. I have here. Oh no, that was for the midterm. You told me y'all want a mixed question with multiple
I
choices.
remembered multiple choice
I
and
did
1 or
not say
2
that.
essays. As a matter of fact, I have it written here. I don't know why I have it written, but I have it.
What'd you
written here.
say? Okay, so for the final exam, you want some multiple choice?
I thought that we'd agreed on multiple choice plus 1 or 2 essay questions. If I'm not mistaken, that's what I have written down.
Well, you sure?
It's not up to me. I'm one small person.
I listening, and no one is saying anything.
I'm just saying what I
How
wrote
many
down
more?
from our discussion at the very beginning
Right.
of the class, of the sessions.
Multiple choice, how many you want? 20? 25?
Ma'am, what is your normal?
Multiple choice?
What is your, okay, can I say this to you? My office, for the most part, have all taken your classes. And when I say to them what our class sounds like and what these questions sounds like, they said, no, that's not the Miss Archer that we took classes with. So let me ask you, what is your normal for an end of term, end of final exam?
All essays.
Oh.
Students
So
don't do too well on multiple choice.
So can you give me a sample question of what your multiple choice would look like? Just random.
Or more welcome.
I can't think of one now, but they are normally very difficult.
I figured.
Yeah. So students, normally they ask for them, and out of 20, they may get 4.
Yeah. Nope.
And then with the essay questions, of course, you have to put in case, and you have to answer the question that is asked, not what you think it's asking, but what is asked.
Which means you have to remember case.
You don't need that many, but it's how you apply it to the question that is asked. A lot of people, they just dump what's in the notes, and then they expect me to go through and pick what the answer is, rather than answering the question that is asked.
I think I'm already having the heebie-jeebies.
Right. So what do your colleagues say?
I'm already having the heebie-jeebies. I know the last session that you would have had 3 of my colleagues, and I think there were 5 essays, if I'm not mistaken. And one of them was so frightened of having to do this thing. She took her test like 3 weeks after the fact. I think you know who it is.
That's normal too.
Oh gosh.
Some
I
people
think
take it
essay
twice.
questions are really easy if you follow the formula. Identify the issue and then do the analysis.
Right.
And then you come to a conclusion. 1, 2, 3.
But some people conclude first.
Oh, okay.
And then they give an analysis. And then they conclude again. The opposite from the beginning.
Unfortunately, exam just make you forget some stuff.
Yes, ma'am.
So that's why you have a review. As soon as you walk in and they say begin, you do a dump. You know what I mean by doing a dump?
Yes, everything that's in your brain, you write it out and then you formulate
write it.
after the fact.
Okay. And I see that when people send in the exam, they put all their papers together and look to the back and I see where they wrote out every little thing they could remember. But if you walk in there and you expect to recall after you finish the first question, you'll find you may go blank. I have students just go blank. They can't finish it. It comes back to them when they're driving home or come back to them the next day. But you have time to think about it. You have 1, 2. You have 2 more classes. Five essays are good. But if you want some multiple choice, I can give you some.
I know everybody can hate me, but I down with five suggestions.
Okay. Anybody else?
I do that all day, every day.
Nobody
So
else saying
therefore,
anything.
you looking in the best interest of not the company.
She's looking in the best interest of the individual. I agree with you, Makita.
Mhm.
You know, at the end of the day, I say, Miss Sacha, you formulate and we simply have to sit.
Exactly.
I mean, you know, my preference is multiple choice, but then again, as I said, I'm one person, and it has to be by consensus. So you know, at the end of the day, I say, you formulate the exam, we sit it. However you formulate it. Have a little mercy. Have a little mercy, you know.
But that's why I normally ask. So I'm not hearing anything. So, and then some people don't do well on essays. Some people don't do well on multiple choice.
Agree.
Sometimes the students will say, just give us 5. That's all we want. Some will say give 10, some say 20.
Ma'am, we will never say 10 or 20. And I think I speak for the company on that note, Makita.
5 or 20 what? Essay questions?
Oh,
no multiple choice.
On top of what?
Essays.
Yeah. Hold on. I don't trust you, man. I just.
What is this?
Oh my goodness. Oh my goodness.
Because you might be there saying, yeah, y'all want this. Okay then.
It sounds like a lose-lose situation, man.
You gotta be careful what you're asking for around here.
Listen.
5 essays.
I ain't trying to pressure nothing.
What is essay?
Ms. Archer, I ain't trying to let you go over and
Short
beyond whatever
answers.
you're trying to be doing.
Uh-huh.
Because I need you to come at no angle. Strong, and I be wrong. you might have to come hard.
Were you able to look at the homework to see if we were in the right wave with the answers?
But remember now, we're doing a review just before.
You're doing a review. I'm going to look at what you all sent. I got another one today, but you're going to have a review. The review will tell you what the question, the topic, and I'll give you a clue as to what my issues or what area the question is focused on.
Ms. Archer, are you a lawyer?
Yes.
Okay. That explains much.
What? What that explains?
Your man is thinking.
These legal terms, that's like break it down in Lehman.
I tried to break it down. I tried to break it down as simple as I can. What do you mean,
You still speaking as if you're speaking to
legalese.
Yeah, like fellow lawyers.
I try to break it down as much as I can. The exam will not be in legalese, it will be in English. Normal English.
But the answers you're looking for.
Well, you're doing a company law class, so it's expected
Yes.
you will show me you know a little bit.
No, but at least look for English in that too. I'm just saying.
Asking a side question now. I want to
Okay,
ask a
go ahead.
sidebar question.
Go ahead, go ahead.
If one wanted to
Hold on, you're breaking up.
You
You're
gone
breaking up.
out.
Yeah, she's still going out.
Yeah.
Try again, Lisa.
Lisa, yeah, you going out.
Type it into the chat.
I hit in chat, but mine is not. Oh. What is she typing?
Nothing is typed here. Nothing came through. Anyway, okay, so let's go with the 5 essay questions and be done with it.
She was typing something. Sure, we could tell us next week.
Okay.
She still has time. So be happy now, because everybody is there quiet, you know, and then they, after the exam, they can come with a different story. So I just making sure.
I just confused, so don't mind.
Why? Why are you confused?
Because I just really ain't sure what's going on. It's just a lot of back and forth. That's why I just being quiet, because I don't know.
No, we all agreeing as to the format for the final exam. We don't have much time left. And so it's either multiple choice and the essay questions, or just essay questions, or you could have essay questions, fill in the blank, and multiple choice. But it has been decided that they would prefer to go with just the 5 essay questions.
Mm.
Such, I feel like M.
You get that bad end and it's sticky.
No, but I mean, it's amongst you all. You all could decide, because some people say they prefer multiple choice. Y'all could decide that y'all want 10 or 20 points in multiple choice.
How about this? How about this? How about if you want to bring the essay questions, you do that. Why don't you have multiple choice as a bonus if your answer just goes towards if you do bad inside the essay?
I've done that before.
So we can go, it can help you if you can answer it or attempt to answer it. It can be
Y'all
something
ain't have
that
no
can,
faith in yourselves.
that can help you. I mean, just to be fair, your persons that want
There's a
multiple
lot of
choice
bargaining.
There's a
and
lot of
persons-
bargaining, hey.
and persons that
Yeah.
want
But
what
at
it is,
least it's
essay.
only the 3 of us who seem to be doing the bargaining.
That's
Yes.
what's scary.
Everybody else is so quiet.
They letting that
Okay.
anxiety stress set in.
Oh,
What anxiety?
Miss Archer,
Yes.
here's a good thing. I mean, just to a poll, a quiet poll, do you mind just sending an email, an individual, an email to everybody and let them fill a quiet, silent poll, and then you tally? How about that?
It could work, but they're still not talking.
I
Are they on?
understand, at least
I'm
I'm
here.
They're there. They're
I'm still
quiet.
here.
You're
still see
giving them
10 people.
exam anxiety.
No, they are not.
No,
still
I
see
think
10
for
people.
me,
Don't
I
believe me.
would say, Miss Archer, I would say you could do the exam in a way where those who want to do multiple choice have the option to do that, and those who want to do just the essays have the option to do that.
That's 2 different exams then.
Yeah,
No,
that's
one
how-
exam.
No,
That's
it's
one
one
exam.
exam, but you have
That's one
extra
exam,
questions.
but you have the option to choose which type of question you want to complete.
You could do 5 essay questions, or you could do 3 questions and 20 multiple choice.
Correct.
You could do 2 essay questions, multiple choice, and short answers. That's what she's saying.
Right. So you have options as to how you complete your exam.
So that means I could complete everything. You just mark it right and give me my points.
No, that don't work like that.
That's how I can need this to be.
I have to give you this joke. You sound like an attorney that I have to do with a divorce. And I said, my client would like to make a final offer at settlement. And he says, I accept the offer for final settlement. However, my client still wants to go over after X, Y, and Z.
Oh my gosh.
Completely lost the point of the offer for settlement.
Oh
Yes.
my gosh.
Okay. Okay.
I'm good with the options because I know what I can do.
Okay. All right, then. Let's see. Okay. Let's see how we formulate that. It's agreed. It's agreed, right?
I'm okay with it.
Okay. Raven?
Silence does not give consent, people.
That's right. Raven? Shaquille? Okay with you?
I'm okay with it.
Okay. All right.
Yeah, I'm okay with it.
What
All
it
right.
is? What we doing? I tell you, I just getting confused.
So you will have choices. You will have choices. It will be mixed media, and meaning you can either do certain amount of multiple choice plus essay question. You know, it'll be a mixed media, and you make the choices will be given to you, and you choose which pattern you want to take.
So you could mix your essay with your multiple choice.
Yeah.
It's based on the choices that Ms. Archer gives. So she may say answer 10, answer 2 essays plus 10 multiple choice, that kind of thing. So it's mixed media.
Okay.
So we would be deciding how, I'm kind of confused by that. So you decide how much multiple choice you answer and how much essay questions you would answer. So
No.
clarity on that.
No.
And will be clear instructions on.
No, you'll
how
have
we
a
interactions.
smorgasbord, Raven. So it'll be a certain amount of multiple questions, a certain amount of essay questions, a certain amount of short answer questions, that kind of thing. And then Mrs. Archer, am I getting this right? Mrs. Archer will give you certain options. You are allowed to answer 10 multiple choice plus 2 essays, or 2 short answers plus 5 multiple choice, or.
So we'll have
and so-
very clear instructions then.
Yes.
Yeah, there'll be
Determine
options.
Either or. Okay, I just
You
wanted
take
to be
option
clear
A,
instructions.
option B, or option C.
Okay.
Whatever, however we do it.
Yeah, that's fine. Once it's
Yeah.
clear, like how exactly it's being structured, like either or. So yeah.
You'll have the options.
Yeah, that's fine. That's fine. Thank you.
Okay. All right. Okay, so we go on with that. Okay, so look out for your question. For your midterm.
Thank
Yes.
you.
Yes. Okay. So enjoy the rest of your evening. Do not stress. Yes. Have a good evening.
Bye-bye.
All right.
All right.
Good
Okay.
night.
Good night.
Good night.